Okay, I'm now reading United States versus Leon within Chapter 3's Arrest, Search, and Seizure and Section 1, the Exclusionary Rule. Justice White delivered the opinion of the court in 1984. This case presents the question whether the Fourth Amendment exclusionary rule should be modified so as not to bar the use in the prosecution's case-in-chief of evidence obtained by officers acting in reasonable reliance on a search warrant issued by a detached and neutral magistrate, but ultimately found to be unsupported by probable cause. The Fourth Amendment contains no provision expressly precluding the use of evidence obtained in violation of its commands, and an examination of its origin and purposes makes clear that the use of fruits of a past unlawful search or seizure works no new Fourth Amendment wrong. The wrong condemned by the amendment is fully accomplished by the unlawful search or seizure itself, and the exclusionary rule is neither intended nor able to cure the invasion of the defendant's rights which he has already suffered. The rule thus operates as a judicially created remedy designed to safeguard Fourth Amendment rights generally through its deterrent effect rather than a personal constitutional right of the person aggrieved. Whether the exclusionary sanction is appropriately imposed in a particular case, our decision makes clear, is an issue separate from the question whether the Fourth Amendment rights of the party seeking to invoke the rule were violated by police conduct. Only the former question is currently before us, and it must be resolved by weighing the costs and benefits of preventing the use in the prosecution's case-in-chief of inherently trustworthy tangible evidence obtained in reliance on a search warrant issued by a detached and neutral magistrate that ultimately is found to be defective. The substantial social costs enacted by the exclusionary rule for the vindication of Fourth Amendment rights have long been a source of concern. Our cases have consistently recognized that unbending application of the exclusionary sanction to enforce ideals of governmental rectitude would impede unacceptably the truth-finding functions of the judge and jury. An objectionable collateral consequence of this interference with the criminal justice system's truth-finding function is that some guilty defendants may go free or receive reduced sentences as a result of favorable plea bargains, particularly when law enforcement officers have acted in objective good faith or their transgressions have been minor. The magnitude of the benefit conferred on such guilty defendants offends basic concepts of the criminal justice system. Indiscriminate application of the exclusionary rule, therefore, may well generate disrespect for the law and the administration of justice. Accordingly, as with any remedial device, the application of the rule has been restricted to those areas where its remedial objectives are thought most efficaciously served. So, I'm wondering if the facts are going to just be as very brief as the warrant was issued neutrally but wasn't but was defective. So I don't know if that's the extent of the facts needing to be given. It might be in the footnotes here. A large quantity of drugs were suppressed on the grounds a warrant had not issued on probable cause, and that affidavit reported on the allegations of an untested informant and limited corroboration by the police surveillance of events themselves as consistent with innocence and with guilt. The court earlier noted that whether this warrant would pass muster under the intervening and less demanding test of Illinois versus Gates has not been briefed or argued, and thus chose to take the case as it comes to us. So, that was sub A. Only the former question is currently before us. I don't know if perhaps that was the That'll be the facts of this case. So, close attention to those remedial objectives has characterized our recent decisions concerning the scope of the Fourth Amendment exclusionary rule. The court has, to be sure, not seriously questioned, in the absence of more efficacious sanction, the continued application of the rule to suppress evidence from the prosecution's case where a Fourth Amendment violation has been substantial and deliberate. Oh no, it's deliberate. Nevertheless, the balancing approach that has evolved in various, so that's new to me, various contexts, including the criminal trials, forcefully suggests that the exclusionary rule be more generally modified to permit the introduction of evidence obtained in the reasonable good faith belief that a search or seizure was in accord with the Fourth Amendment. Only when a warrant is grounded upon an affidavit knowingly or recklessly false has the court set forth a rationale for suppressing evidence. So, obtained pursuant to a search warrant. In other areas, so, that's interesting. This is like all new information to me. In other areas, it has simply excluded such evidence without considering whether Fourth Amendment interests will be advanced. To the extent that proponents of exclusion rely on its behavioral effects on judges and magistrates in these areas, the reliance is misplaced. First, the exclusionary rule is designed to deter police misconduct rather than to punish the errors of judges and magistrates. So that's the legislative intent. Second, there exists no evidence suggesting that judges and magistrates are inclined to ignore or subvert the Fourth Amendment, or that lawlessness among those actors requires application of the extreme sanction of exclusion. So it's like the wrong actors. Judges and magistrates are not the ones that are searching and seizing. Third, the most important, we discern no basis and are offered none for believing that exclusion of evidence seized pursuant to the warrant will have a significant deterrent effect on the issuing judge or magistrate. So this is like public policy. And many of the factors that indicate that the exclusionary rule cannot provide an effective special or general deterrent for individual offending law enforcement officers apply as well to judges and magistrates. And to the extent that the rule is thought to operate as a systemic deterrent on a wider audience, and clearly can have no such effect on individuals empowered to issue warrants. Judges and magistrates are not adjuncts to the law enforcement team as neutral judicial officers. They have no stake in the outcome of particular criminal prosecutions. The threat of exclusion thus cannot be expected significantly to deter them. Imposition of the exclusionary sanction is not necessarily meaningful to inform judicial officers of their errors, and we cannot conclude that admitting evidence obtained pursuant to a warrant while at the same time declaring that the warrant is somehow defective in any way reduce judicial officers' professional incentives to comply with the Fourth Amendment, encourage them to repeat their mistakes, or lead to the granting of all colorable warrant requests. If exclusion of evidence obtained pursuant to a subsequently invalidated warrant is to have any deterrent effect, therefore, it must alter the behavior of individual law enforcement officers or the policies of their departments. One could argue that applying the exclusionary rule in cases where the police failed to demonstrate probable cause in the warrant application deters future inadequate presentations or magistrate shopping, and thus promotes the end of the Fourth Amendment. Suppressing evidence obtained pursuant to a technically defective warrant supported by probable cause encourage officers to scrutinize more closely the form of the warrant and point out suspected judicial errors. We find such arguments speculative and conclude that suppression of evidence obtained pursuant to a warrant should be ordered only on a case-by-case basis, and only in those unusual cases in which exclusion will further the purposes of the exclusionary rule. We have frequently questioned whether the exclusionary rule can have any deterrent effect when the offending officers acted in an objectively reasonable belief that their conduct did not violate the Fourth Amendment. No empirical research proponent or opponent of the rule has yet been able to establish any assertion whether the rule has a deterrent effect. But even assuming that the rule effectively deters some police misconduct, it provides incentives for law enforcement profession as a whole to conduct itself in accord with the Fourth Amendment. It cannot be expected and should not be applied to deter objectively reasonable law enforcement activity. So, this is particularly true, we believe, when an officer acting with objective good faith has obtained a search warrant from a judge or magistrate and acted within its scope. In most such cases, there is no police illegality and thus nothing to deter. It is the magistrate's responsibility to determine whether the officer's allegations establish probable cause, and if so, to issue a warrant comporting in form with the requirements of the Fourth Amendment. In the ordinary case, the officer cannot be expected to question the magistrate's probable cause determination or his judgment that the form of the warrant is technically sufficient. Once the warrant issues, there is literally nothing more the policeman can do in seeking to comply with the law. Penalizing the officer for the magistrate's error rather than his own cannot logically contribute to the deterrence of Fourth Amendment violations. We conclude that the marginal or non-existent benefits produced by suppressing evidence obtained in objectively reasonable reliance on a subsequently invalidated search warrant cannot justify the substantial cost of exclusion. We do not suggest, however, that exclusion is always inappropriate in cases where an officer has obtained a warrant and abided by its terms. The officer's reliance in the magistrate's probable cause determination on the technical sufficiency of the warrant he issues must be objectively reasonable. And it's clear that in some circumstances the officer will have no grounds for believing that the warrant was not properly issued. Suppression, therefore, remains an appropriate remedy if the magistrate or judge in issuing the warrant was misled by information in the affidavit that the affiant knew was false or would have known was false except for his reckless disregard of the truth. I'm guessing this is like a fact of this case. I don't know. The exception we recognize today will also not apply in cases where the issuing magistrate wholly abandoned his judicial role in a manner condemned by Logie Sales, Inc. v. New York, 1979. And in such circumstances, no reasonably well-trained officer should rely on the warrant, nor would an officer manifest objective good faith in relying on a warrant based on affidavits, so lacking an indicia of probable cause as to render official belief in its existence entirely unreasonable. Finally, depending on the circumstances of the particular case, a warrant may be so facially deficient in failing to particularize the place to be searched or the things to be seized that the executing officers cannot reasonably presume it to be valid. The good faith exception for searches conducted pursuant to warrants is not intended to signal our unwillingness strictly to enforce the requirements of the Fourth Amendment, and we do not believe that it will have this effect. As we have already suggested, the good faith exception, turning as it does on objective reasonableness, should not be difficult to apply in practice. When officers have acted pursuant to a warrant, the prosecution should ordinarily be able to establish objective good faith without a substantial expenditure of judicial time. Nor are we persuaded that the application of the good faith exception to searches conducted pursuant to warrants will preclude review of the constitutionality of the search or seizure, deny needed guidance from the courts, or freeze Fourth Amendment law in its present state. There is no need for courts to adopt the inflexible practice of always deciding whether the officer's conduct manifested objective good faith before turning to the question whether the Fourth Amendment has been violated. If the resolution of a particular Fourth Amendment question is necessary to guide future action by law enforcement officers and magistrates, nothing will prevent reviewing courts from deciding that question before turning to the good faith issue. Indeed, it frequently will be difficult to determine whether the officers acted reasonably without resolving the Fourth Amendment issue. Even if the Fourth Amendment question is not one of broad import, reviewing courts could decide in particular cases the magistrates under their supervision need to be informed of their errors and so evaluate the officer's good faith only after finding a violation. In other circumstances, those courts could reject suppression motions posing no important Fourth Amendment questions by turning immediately to the considerations of the officer's good faith. We have no reason to believe that our Fourth Amendment jurisprudence would suffer by allowing reviewing courts to exercise an informed discretion making this choice. In the absence of an allegation that the magistrate abandoned his detached neutral role, suppression is appropriate only if the officers were dishonest or reckless in preparing their affidavit or could not have harbored an objectively reasonable belief in the existence of probable cause. Only respondent Leon has contended that no reasonably well-trained police officer could have believed that there existed probable cause to search his house. Significantly, the other respondents advanced no comparable argument. Officer Rumbach's application for a warrant clearly was supported by much more than a bare-bones affidavit. The affidavit related the results of an extensive investigation, and as the opinions of the divided panel of the Court of Appeals make clear, provided evidence sufficient to create disagreement among thoughtful and competent judges as to the existence of probable cause. Under these circumstances, the officer's reliance on the magistrate's determination of probable cause was objectively reasonable. And application of the extreme sanction of exclusion is inappropriate. Accordingly, the judgment of the appeals is reversed. So, Blackman concurs, Brennan Marshall dissent, and their opinions are here. It's going to be, they're kind of long, actually. So, looks like Kennedy concurring in part and concurring in the judgment. Breyer, Stevens, Souter, and Ginsburg, no surprise. For Renegades dissent. With more long opinion, which will take us, when I'm done reading it, to page 86. So that's like 6 plus 8, 14 pages of dissenting opinion. So, Blackman's concurrence. Any empirical judgment about the effect of the exclusionary rule in a particular class of cases necessarily is a provisional one. If it should emerge from the experience contrary to our expectations, the good faith exception to the exclusionary rule results in a material change in police compliance with Fourth Amendment. We shall have to reconsider what we've undertaken here. The logic of a decision that rests on untested predictions about police conduct demands no less. So, looking for deterrence. No deterrence theory. Brennan and Marshall join, dissenting. The majority reading of the Fourth Amendment appears plausible because, as critics of the exclusionary rule never tire of repeating, the Fourth Amendment makes no express provisions for the exclusion of evidence secured in violation of its commands. A short answer to this claim, of course, is that many of the Constitution's most important imperatives are stated in general terms, and the task of giving meaning to these precepts is therefore left to subsequent judicial decision-making in the context of concrete cases. The nature of our Constitution, as Chief Justice Marshall Longo explained, requires that only its great outline should be marked, its important objectives designated, and the minor ingredients which compose those objects be deduced from the nature of the objects themselves. A more direct answer may be supplied by recognizing that the amendment, like other provisions of the Bill of Rights, restrains the power of the government as a whole. It does not specify only a particular agency and exempt all others. The judiciary is responsible no less than the executive for ensuring that constitutional rights are respected. When that fact is kept in mind, the role of the courts and their possible involvement in the concerns of the Fourth Amendment comes into sharper focus because seizures are executed principally to secure evidence and because such evidence generally has utility in our legal system only in the context of a trial supervised by a judge. It is apparent that the admission of illegally obtained evidence implicates the same constitutional concerns as the initial seizure of that evidence. Indeed, by admitting lawfully seized evidence, the judiciary becomes a part of what is a fact of single governmental action prohibited by the terms of the amendment. Once a connection between the evidence gathering role of the police and the evidence admitting function of the courts is acknowledged, the plausibility of the court's interpretation becomes more suspect. Certainly nothing in the language or history of the Fourth Amendment suggests that a recognition of this evidentiary link between the police and the courts was meant to be foreclosed. It is difficult to give any meaning at all to the limitations imposed by the amendment if they are read to prescribe only certain conduct by the police, but to allow other agents of the same government to take advantage of evidence secured by the police in violation of its requirements. The amendment, therefore, must be read to condemn not only the initial unconstitutional invasion of privacy, which is done, after all, for the purpose of securing evidence, but also the subsequent use of any evidence so obtained. Such a conception of the rights secured by the Fourth Amendment was unquestionably the original basis of what has come to be called the exclusionary rule when it was first formulated in Weeks v. United States. The question whether the exclusion of evidence would deter future police misconduct was never considered a relevant concern in the early cases. So, in those formative decisions, the court plainly understood that the exclusion of legally obtained evidence was compelled not by judicially fashioned remedial purposes, but rather by a direct constitutional command. Indeed, no other explanation suffices to account for the court's holding in Mapp, since the only plausible predicate for the court's decision that the states were bound by the 14th Amendment to honor the Weeks Doctrine is that the exclusionary rule was part and parcel with the Fourth Amendment's limitation upon governmental encroachment into individual property. Despite this clear pronouncement, however, the court has gradually pressed the deterrence rationale for the rule back to center stage. The various arguments advanced by the court in this campaign have only strengthened my conviction and that the deterrence theory is both misguided and unworkable. First, the court has frequently bewailed the cost of excluding reliable evidence. In large part, this criticism rests upon the refusal to acknowledge the function of the Fourth Amendment itself. If nothing else, the amendment plainly operates to disable the government from gathering information, securing evidence in certain ways. In practical terms, of course, this restriction of official power means that some incriminating evidence inevitably will go undetected if the government obeys the constitutional restraints. It is the loss of that evidence that is the price our society pays for enjoying the freedom of privacy safeguarded by the Fourth Amendment. Thus, some criminals will go free, not in justice than Judge Cardozo's misleading epigram because the constable has blundered, but rather because the official compliance with Fourth Amendment requirements makes it more difficult to catch criminals. Understood this way, the amendment directly contemplates that some reliable and incriminating evidence will be lost to the government. Therefore, it is not the exclusionary rule, but the amendment itself that has imposed this cost. Okay. In addition, the court's decision over the past decade have made plain that the entire enterprise of attempting to assess the benefits and costs of the exclusionary rule in various contexts is a virtually impossible task for the judiciary to perform honestly and accurately. Although the court's language in those cases suggests that some specific empirical basis may support its analysis, the reality is that the court's opinion represent inherently unstable compounds of intuition, hunches, and occasional pieces of partial and often inconclusive data. To the extent empirical data is available regarding the general costs and benefits of the exclusionary rule, it has shown, on the one hand, that the court acknowledges today that the costs are not as substantial as critics have asserted in the past, and on the other hand, that while the exclusionary rule may well have certain deterrent effects, it is extremely difficult to determine with any degree of precision whether the incidence of unlawful conduct by police is now lower than it was prior to MAP. The court has sought to turn this uncertainty into an advantage by casting the burden of proof upon proponents of the rule. Obviously, however, the assignment of the burden of proof on an issue where evidence does not exist and cannot be obtained is outcome determinative. The assignment of the burden is merely a way of announcing a predetermined conclusion. By remaining within its readout of empiricism and by basing the rule solely on the deterrence rationale, the court has robbed the rule of legitimacy. A doctrine that is explained as if it were an empirical proposition, but for which there is only limited empirical support, is both inherently unstable and an easy mark for critics. The extent of the court's fidelity to the Fourth Amendment requirements, however, should not turn on such statistical uncertainties. Even if I were to accept the court's general approach to the exclusionary rule, I could not agree with today's result. At the outset, the court suggests that society has been asked to pay a high price in terms of setting guilty persons free or impeding their proper functioning of trials as a result of excluding relevant physical evidence in cases where the police, in conducting searches and seizure evidence, have made only an objectively reasonable mistake concerning the constitutionality of their actions. But what evidence is there to support such a claim? Significantly, the court points to none, and indeed, as the court acknowledges, recent studies have demonstrated federal and state prosecutors very rarely drop cases because of potential search and seizure problems. For example, in 1979, a study prepared at the request of Congress by the General Accounting Office reported that only 0.4% of all cases actually declined for prosecution by federal prosecutors were declined primarily because of illegal search problems. If the GAO data are restated as a percentage of all arrests, the study shows that only 2.2% of all felony arrests are declined for prosecution because of potential exclusionary rule problems. Of course, these data describe only the cost attributable to the exclusion of evidence in all cases. The cost due to the exclusion of evidence in the narrow category of cases where police have made objectively reasonable mistakes must necessarily be even smaller. The court, however, ignores this distinction and mistakenly weighs the aggregated cost of exclusion in all cases, irrespective of the circumstances that led to exclusion, against the potential benefits associated with only those cases in which evidence is excluded because police reasonably but mistakenly believe that their conduct does not violate the Fourth Amendment. When such faulty scales are used, it is little wonder that the balance tips in favor of restricting the application of the rule. What then supports the court's insistence that this evidence be admitted? Apparently, the court's only answer is that even though the costs of exclusion are not very substantial, the potential deterrent effect in the circumstances is so marginal that exclusion cannot be justified. The key to the court's conclusion in this respect is its belief that the prospective deterrent effect of the exclusionary rule operates only in those situations in which police officers, when deciding whether to go forward with some particular search, have reason to know their plain conduct will violate the requirements of the Fourth Amendment. But what the court overlooks is that the deterrence rationale for the rule is not designed to be, nor should it be, thought of as a form of punishment of individual police officers for their failure to obey the restraints imposed by the Fourth Amendment. Instead, the chief deterrent function of the rule is its tendency to promote institutional compliance with the Fourth Amendment requirements on the part of the law enforcement agencies generally. Thus, as the court has previously recognized over the term, the demonstration provided by the exclusionary rule that our society attaches serious consequences to violations of constitutional rights is thought to encourage those who formulate law enforcement policies and the officers who implement them to incorporate Fourth Amendment ideals into their value system. It is only through such an institution-wide mechanism that information concerning Fourth Amendment standards can be effectively communicated to rank and file officers. If the overall educational effort of the exclusionary rule is considered, application of the rule to even those situations in which individual police officers have acted on the basis of reasonable but mistaken belief that their conduct was authorized can still be expected to have a considerable long-term deterrent effect. If evidence is consistently excluded in these circumstances, the police department will surely be prompted to instruct their officers to devote greater care and attention to providing sufficient information to establish probable cause when applying for a warrant, and to review with some attention the form of the warrant that they have been issued, rather than automatically assuming that whatever document the magistrate has signed will necessarily comport the Fourth Amendment requirements. After today's decision, however, that institutional incentive will be lost. Indeed, the court's reasonable mistake exception to the exclusionary rule will tend to put a premium on the police ignorance of the law. Armed with the assurance provided today's decision that the evidence will always be admissible whenever an officer has reasonably relied upon a warrant, police departments will be encouraged to train officers that if a warrant has simply been signed, it is reasonable without more to rely on it, since in close cases there will no longer be any inception to err on the side of constitutional behavior. And then there's the premium. Is that what they said? Premium on police ignorance of the law. And then likewise, no incentive to err on the side of constitutional behavior. Police would have every reason to adopt a let's wait until it's decided approach in situations in which there is a question about a warrant's validity or the basis for its issuance. Although the court brushes these concerns aside, a host of grave consequences can be expected to result from its decision to carve this new exception out of the exclusionary rule. A chief consequence of today's decision will be to convey a clear and unambiguous message to magistrates that their decisions to issue warrants are now insulated from subsequent judicial review. Creation of this new exception or good faith reliance upon a warrant implicitly tells magistrates that they need not take much care in reviewing warrant applications, since their mistakes will from now on have virtually no consequence in their decision to issue a warrant. Was correct, the evidence will be admitted. If their decision was incorrect, but the police relied in good faith on the warrant, the evidence will also be admitted. Inevitably, the care and attention devoted to such an inconsequential chore will dwindle. Although the court is correct to note the magistrates do not share the same stake in the outcome of the criminal case as the police, they nevertheless need to appreciate that their role is of some moment in order to continue performing the important task of carefully reviewing warrant applications. Today's decision effectively removes that incentive. Moreover, the good faith exception will encourage police to provide only a bare minimum of information in future warrant applications. The police will now know that if they can secure a warrant, so long as the circumstances of its issuance are not entirely unreasonable, the police conduct pursuant to that warrant will be to establish probable cause adequately, because reviewing courts would examine the magistrate's judgment carefully. It has now been so completely vitiated that police need only show that it was not entirely reasonable under the circumstances of the particular case for them to believe that the warrant they were issued was valid. The long-run effect unquestionably will be to determine the integrity of the warrant process. Oh my God. That can't be right. Oh, good. This is the end. Okay, Justice Stevens dissenting. It is probable, though admittedly not certain, which means that the Hudson versus Michigan is where those other dissenting opinions came from. So yes, so Justice Stevens dissents. This is the last two paragraphs. It is probable, though admittedly not certain, that the Court of Appeals would now conclude that the warrant in Leon satisfied the Fourth Amendment if it were given the opportunity to reconsider the issue in light of Gates. Adherence to our normal practice following the announcement of a new rule would therefore postpone and probably obviate the need for the promulgation of the broad new rule the court announces today. When the court goes beyond what is necessary to decide the case before it, it can only encourage the perception that it is pursuing its own notions of wise social policy rather than adhering to its judicial role. I do not believe the court should reach out to decide what is undoubtedly a profound question concerning the administration of criminal justice before assuring itself that this question is actually and of necessity presented by the concrete facts before the court.